Okay. Welcome to the afternoon session of the Kansas Court of Appeals. We're here right now on case number 121980, State of Kansas versus James R. Quinton. Would the parties please state their appearances?
Thank you, Your Honor. Carl Maughan on behalf of the appellant, James Quinton.
May it please the court, Thomas R. Stanton, Reno County District Attorney, on behalf of the appellee, State of Kansas.
Mr. Stanton, were you on the brief on this case?
No, ma'am. Mr. Schroeder was on the brief. He retired and is actually going to be the next district judge here.
Okay.
I took his place, so I'm standing in today.
Okay. Would you mind just giving me your bar number?
14568.
Okay, great. All right. You both are old pros at appearing before this court, so I don't need to give much explanation, except you know that we know the facts of the case, and so you really don't need to relay as much of those to take up your 15 minutes. And speaking of 15 minutes, Mr. Maughan, would you like any time in rebuttal?
Yes, Your Honor. Could I have 5 minutes, please?
Okay. I'd also like to, I forgot to introduce myself. I'm Chief Judge Karen Arnoldberger of the Kansas Court of Appeals. With me on the panel today is former Chief Judge Thomas Malone and Senior Judge Richard Walker, who hails from the 9th Judicial District, where he was a judge for 31 years before becoming a senior judge for us. So with that, Mr. Maughan, you may begin.
Thank you, Your Honor. First, before I start, I just, for a number of reasons, I am doing this at home. So I'm praying that my dog doesn't start barking in the middle of the arguments, but if they do, please bear with me a little bit. Your Honor, the appellant's position in this case is fairly simple. He was convicted and sentenced after a jury trial. And as part of that sentence, he was ordered to pay restitution to 3 different government agencies. He did pay that restitution. The Court of Appeals eventually reversed the conviction and the sentence on a 1507. And it's our argument that by reversing and vacating the sentence, that vacated the restitution order as well. Mr. Quinton then did enter a plea. The plea agreement did not address restitution at all. The state did not request restitution, and the judge did not order restitution in sentencing. The appellant's position is simply that that restitution was paid under an order that was no longer valid, and that restitution should now be returned to him. He wrote a letter but filed a motion, I guess is the way it was interpreted, requesting a return of that money, and Judge Rose denied that. Your Honor, for our purposes, it's simply a case of this money was paid under an invalid order and should be returned to him. At the time, that is, if the state does not return the money, it constitutes a taking under the Fifth Amendment. And so obviously we're here simply saying this was an invalid court order and it should be returned to Mr. Quinton.
Mr. Maughan, I have a question. If you know, and maybe you don't, at the resentencing hearing, apparently there was some discussion, but we don't have any record of the plea agreement from the resentencing or a transcript of that. So how do we know? And I don't, maybe it doesn't exist or wasn't transcribed. Why don't we have that information? If you know.
Well, Judge, I don't know. I guess I had acted under the assumption that it was part of the record. It's been a while since I wrote the brief, and so I can't remember whether it was or wasn't.
Wouldn't it be important that we know what happened at that point, what was said, and what was agreed to at that hearing?
Not from my position, but I think it would be from your position and from the state's position. Our position is that what transpired at the motion hearing capsulated everything that had occurred in the case. There wasn't any correction. Yes, Your Honor.
Let me ask you a few basic questions.
Sure.
First of all, why are you calling the $4,050 payment for bids, attorney fees. Why are you calling that restitution?
Because that's how it was ordered, and it was ordered to be paid back to bids as restitution. It's not something that is automatic. It's something that has to be paid, ordered by the court as part of the sentencing.
Well, I know it's ordered to be paid back as attorney fees, and there's a statute that covers that, but I've never seen anyone refer to it as restitution before. That's usually what goes to the victim, isn't it?
Not necessarily. Well, ordinarily that's correct, but I would say any order to repay a loss that is incurred by somebody as a result of the defendant's actions would be restitution.
Would we agree that the $960 to the Crime Victim Compensation Board, that would be restitution, wouldn't it?
Well, it's my understanding of the way the Crime Victim Compensation Board works is they put out the funds, and then the defendant pays them back. So that would be restitution. Similar in the bids situation, bids pays the attorney, and the defendant pays bids back. So it would be restitution towards bids for the defendant's actions.
But the Cummings case.
We just want one final question.
I'm sorry.
Of the $5,512 that your client did pay, is there any way to break that down so that we would know how much of that went to the Crime Victim Compensation Board?
Yes, Your Honor. I don't have those amounts right with me, but it would be in the order of sentencing as to who the restitution would have been paid to, the original order of sentencing.
So are you saying he paid everything? He paid everything related to that case that he was ordered to pay?
All paid, yes.
Yeah.
So my position on this is that even though it wasn't necessarily money paid directly to the victim, it was money ordered under sentencing to be paid. And whether it's restitution or whether it is money that was paid as part of the sentence is somewhat irrelevant, and maybe it's going down the wrong track, because that was ordered as part of the sentencing, whether it was to the victim, to the Crime Victim Compensation Board, to bids, or to the KBI. It was ordered as part of sentencing. The issue was that sentence was vacated, and Mr. Quinton had requested the money paid back to him. None of those funds were ordered to be paid during the second sentencing. If I may just address some of the state's claims, the lack of standing seems to me to be somewhat nonsensical to some degree. The defendant didn't have to raise this at the resentencing issue because he's not in any position where he has to request or object to things that aren't being done at the sentencing. This was the state's obligation to raise, to ask the court to impose restitution or other fees to be paid as part of the sentencing. It is not the defendant's position to have to say this. And yet the state has been arguing in their brief that because the defendant didn't raise this issue at sentencing, somehow he doesn't have standing to argue this issue now. It's our position that he raised the issue when he requested the return of the funds, and he had no obligation to do so at the original sentencing. This issue shouldn't be confused with what I raised in my brief is the raising of the Fifth Amendment claim, which is something that I did not raise in oral arguments at the hearing. Frankly, I didn't think I would need to. It was, to me, a simple case of that the sentence was given, the sentence was vacated, and we're now saying that money was paid when there was no sentence. And so I do think that there is an exception in that this issue is entirely governed by law and facts that are known and I would suggest are admitted, and that raising the constitutional issue today for the first time falls within that exception.
Okay. Any other questions?
Well, but is it determinative? I mean, even if we, by that argument, aren't we going to have to remand it for further findings of the district court? So how can that be a determinative issue? How can our ruling be determinative on this?
Well, Judge, I think that you would need to remand it simply for the district court to order that the money be returned to him. All the findings have been made. There was no restitution ordered at the sentencing hearing, and there was no, and the previous sentence was vacated. And so at this point, it's simply a case of, is there money that was paid that was not ordered in the sentence? And yes, it was. And I would argue that the defendant ought to be repaid those monies because it was paid under an invalid sentence.
I understand your argument.
Thank you, Your Honor.
Any other questions? Thank you. You'll still have your 5 minutes in rebuttal. Okay. Mr. Stanton.
Thank you, Your Honor. I will just respond to one of the questions that was asked as far as the record. Although not argued in the brief because it's raised here, the defendant or the appellant has the obligation to provide a record upon which meaningful review can be made. So if this court finds that that record is insufficient, then that falls on the appellant for failure to provide that record. Your Honor, I thought Mr. Schroeder did a good job in arguing and presenting these issues to the courts. When you start off with, obviously the standard here is de novo, so it is up to this court to determine the issues. I would note in looking at the brief that Mr. Schroeder cited KSA 65,004. And the reason that's important is that is a statute that lays out a remedy in exactly this type of situation, in which a person has been convicted and then has paid in fees. Now, if you look at that statute, which is cited fully on pages 30 to 31 of the brief, one of the requirements of that statute is that in order to prevail, a claimant has to establish by a preponderance of the evidence that he was convicted of a felony, that the judgment was reversed or vacated, and that he did not commit the crime or suborn perjury during the proceedings. In this case, he came back in and he pled guilty. So what he's trying to do basically by this letter, as I read the facts and the record, is trying to get this before the court via the letter when it should have been filed under that statute. And that statute requires that it be served upon the Attorney General. None of that was done. This court in the past has construed pro se motions as being motions pursuant to certain statutes. And I suppose this court could look at this letter and the arguments being made and construe it as a motion, even though it wasn't properly served upon the Attorney General. And even under those circumstances, he would have to have shown that he did not commit the crime to have those funds returned to him. So it seems to me that his failure to file under that motion and to carry a burden pursuant to that motion that he was wrongly convicted and then was found not guilty would give this court guidance as to how to determine this case. It seems to me that looking at what is required under that statute, he has failed to show that he is entitled to relief because he subsequently was found guilty of rape. And so all of the costs that were associated with the original case that he was assessed would also be associated with this particular conviction, and therefore would have also been required to have been paid under that statute. The other thing I think is important to note here, and I would ask, I don't see a reference to the record, Your Honors, but on page 22 of Mr. Schroeder's brief, he does lay out the costs that were ordered. And according to the brief, it was $967.87 to the Crime Victims Compensation Board, $400 KBI fee, and a $4,000 bids fee. Now, the defendant did not appeal that. He did not object to those figures, and he paid them. I guess one of the questions for the court is, how could the court on the second sentencing have even assessed those? They were previously paid. They were no longer owed. So how could the court have assessed costs that had already been paid by the defendant? By analogy, if you had a theft case and the parties came before the court on a guilty verdict or a guilty plea, and the victim had already made, the defendant had already made the victim whole by repaying that restitution, the court wouldn't have authority to order that restitution. It's already been paid. And so in this case, when we came back for sentencing the second time, all of those had been paid. Now, could the court have referenced them in the sentencing and said, yes, if these had not been paid, I would be assessing them, but they've already been paid. And it's clear that, yes.
Real
yes,
quickly, are you or are you not relying upon this clause someplace in the resentencing or the redoing of the when the plea negotiations were entered into, which says that the defendant is waiving all issues, in effect, for waiving the right to appeal any issues, except I think the ones that you criminal history score and all those things that you really can't waive. Always got the right to reserve them. Are you relying on that language here?
Certainly. Part of the plea agreement was that he would waive his right to appeal. So yes, we're relying on that. The issue I think that the court has is whether or not somehow this letter amounts to an appeal. If it amounts to an appeal, it's way out of time. It's 2 years out of time, apparently. But the bottom line is that he did waive his right to appeal all issues except for an illegal sentence. And we have been using that as part of our agreements for several years now, the waiver of appeal when it comes to guilty pleas. So yes, we still are relying on that. But if the court were to find that that was somehow insufficient, I wanted to argue all the issues as well.
I understand.
And he filed this motion in the underlying criminal case, right?
Well,
this wasn't a separate civil action for refunding of money. This was a motion he filed in an existing case sometime after it was over.
That is correct. From the evidence that the record that I have, he filed, or he submitted on January 30th of 2019 a letter specifying this particular case and asking the court.
How long after this case he was sentenced on this case?
He was sentenced the second time.
I can look it up. That's
on April 25th. No, he pled guilty on April 25th, was sentenced on May 10th of 2018. Okay. So it would have been 7 months later that he wrote I said 2 years, but it would have been 7 months later that he wrote the letter.
Thank you.
So if it is an appeal, then it's out of time.
Mm-hmm.
I believe that Mr. Schroeder covered what the statutory requirements are for each of those. I know that having been a drug prosecutor for most of my career, the KBI fees are mandatory unless there is a record made at the time of sentencing that somehow that person is unable to pay. Having already paid that, the statute would have required that payment as a matter of law. Bids, again, also require some sort of a discussion between the court and the defendant as far as ability to pay. And it would be my position that he had clearly shown the ability to pay since they were already paid. And it would be, if we're talking about equity, which Mr. Schroeder also covered, certainly it would not be equitable to require the victim to now, or even the Crime Victims Compensation Board to pay the costs resulting from the commission of this crime. He committed the rape, and so the victim's costs should be assessed to him. So those are our primary arguments. I would also incorporate by reference all the arguments made in the brief. If the court has further questions, I stand for questions.
Any other questions?
Yep.
Thank you. Mr. Vaughn, you'll have your 5 minutes.
Thank you, Honor. First of all, I would like to point out that in the record, volume 9 is the transcript of the first sentencing, and volume 10 is the transcript of the second sentencing. And that's in the record that I have, that those volumes are part of the record. I can't vouch for whether you received them or not, but the record I had those included. First of all, I'd like to address the statutory issue of the 60-5004. This wasn't a case where we're alleging that he was wrongfully convicted in this case. He actually pled guilty. The fact is that the conviction and sentence, the earlier sentence, had been vacated. The question is whether or not at the time of the second sentencing, when the state failed to request these payments, either whether they're restitution or other payments, and the state failed to request them and the court did not order them, whether or not the state agency should now benefit from Mr. Quinton's previous paying of those. So the statute doesn't quite apply in this case. It is something that would be a completely different situation if Mr. Quinton had been wrongfully convicted under this case number and acquitted or set free later on. But this does not apply in this case. He was convicted and then sentenced, and the sentencing did not order any payments to any of the state agencies. With regard to whether or not this was reliance on the, whether the state can rely on the waiver of the right to appeal, Mr. Quinton is not appealing the sentence. He was happy with the sentence. He is appealing the fact that the state, that the court refused to order the state to give the money that he had previously paid to them. It's not a appeal of the sentence or the conviction. It is an appeal of a later motion. And if the state wants to talk about it as an illegal sentence, this motion was filed 7 months after sentencing. It could have been construed as a motion to correct a legal sentence, meaning that the state had taken the money and assumed it as part of a sentencing when that money wasn't ordered. So we could construe it that way if we wished, but that's not the way we're presenting it. We're presenting it as the sentence did not include any order to pay any monies, and Mr. Quinton is simply requesting a refund of monies that are already being paid. If I could address the issue of equity, it is true that in a court of equity, ordinarily the party who is seeking equity would have to come with clean hands. The state is trying to conflate Mr. Quinton's conviction and admission to rape with the equity in this situation of state government agencies retaining funds. Mr. Quinton's hands with regard to the state agencies are clean. He has no, there's no violation of equity or clean hands with regard to the state agencies. He is not requesting any monies paid back from the victim in this case. He is simply requesting that the state agencies pay the money back. So we can't conflate Mr. Quinton's admitted wrongdoing with regard to the victim with regard to, and the state's wrongdoing in not providing monies back to Mr. Quinton when those monies were not ordered to be paid under sentencing. So, Your Honors, I would argue that if the state does not provide this money back to Mr. Quinton, it is a taking. He has not, there has not been any due process hearing. Well, you could argue that there has been and simply wasn't ordered. If you could argue that the sentence was a due process hearing and it wasn't ordered. So In that case, the state is holding on to money that it should not be holding on to, and both law and equity. And we are approaching this from, by arguing the equity situation, I don't want to give the impression that I'm claiming this is an equity issue. I'm claiming this is a legal issue. I'm just addressing the equity argument of the state. But either way, whether it's under law or equity, we would argue that the state should provide these funds back to Mr. Quinton, which were paid despite the fact they were not ordered in sentencing. Unless the panel has any other questions, that's
I have a question, Mr. Mullen.
Yes,
if the court at the second hearing didn't order the bids fees and the crime victim fees to be paid again, because the record was clear that they already had been paid, which is what the prosecutor argued at sentencing, how has your client lost anything to begin with? If he gets that money back, that's going to be a windfall for him, isn't it?
No, Your Honor. They were ordered to be paid on a sentence that was vacated, that was set aside, that is a nullity. And so the payment of those funds was not something that was ordered by the court. From a legal standpoint, that order was completely set aside. We went to sentencing. The state did not ask for payment of these monies, and the court did not order them. So it wouldn't be a windfall to him. It is a windfall to the state government to not return the monies to Mr. Quinton, who is the rightful owner of them.
Well, I'm not following that, but I'll leave it alone for now. Thank you.
Thank you.
Any other questions from the panel? Okay, thank you. That'll conclude this matter. We appreciate your argument. We will take this matter under advisement, issue a decision.